If you submitted an UK immigration application probably back 10-15 years back and you had refusal, and you think, oh, it's more than 10 years and I don't need to disclose this. But the fact is you need to disclose all your previous refusal. Now if you read the immigration application form when you complete it online, the question is, have you ever been refused for UK visa or visa for any other country? What it means is you just need to disclose no matter when it was refused, whether it's for UK or whether it's for any other country. In this video, I want to cover top 5 reasons of UK visa refusals. Look, we are a multi-award winning legal 500 10 plus years experience immigration law firm, and we have sold probably 4,000 plus clients, and we have 1,000 plus reviews on Trustpilot and Google. And the reason I'm mentioning this is we have a huge experience which I want to share with you, and there are typical common 5 reasons I have discovered throughout my career, and I want to share it with you so that you don't repeat these mistakes and get your UK visa approved straight away without refuse. So let's focus on number 1 reason. So when I do consultation, I get to see refusals of clients where they have made mistakes, and there is a pattern. There is a common pattern of these refusals. And what I've done is I've found 5 common reasons of these refusals. And if I share this with you today, it might help you to avoid refusals for your UK visa application. So number 1 reason is not disclosing your previous immigration history or material fact. What do I mean by that? If you submitted an UK immigration application probably back 10-15 years back and you had refusal, and you think, oh, it's more than 10 years and I don't need to disclose this. But the fact is you need to disclose all your previous refusal. Now if you read the immigration application form when you complete it online, the question is, have you ever been refused for UK visa or visa for any other country? What it means is you just need to disclose no matter when it was refused, whether it's for UK or whether it's for any other country. You just need to disclose. If you disclose this information, then it might not attract refusal straight away. But if you do not, and if the Home Office was to find that you failed to disclose the information of previous refusal, they will refuse your application with an allegation of deception. Now that is more dangerous, very dangerous, because when you will be alleged of a deception, you might even attract a mandatory ban for the future UK visa application for 5-10 years ban. Automatic reason of refusal, straight. So that's very dangerous. So please, when you complete the application form, do not fail to disclose your previous immigration history, any previous UK visa refusal or visa refusal for any other country. If you don't remember, for an example, say, oh yeah, it was few years back and I don't remember, I don't have reference number, I don't have dates, then mention that. Say approximately in April 2015, or let's say in May 2003, I was once refused for UK visa for X, Y and Z reason as far as I remember. So disclosing that fact, even vaguely, as much as you remember, will help you not to get refused under deception, because you are trying your best to disclose the information as much as possible, right? You might not sometime remember precisely, or you probably might not be able to pull out the record. One more thing on that note I want to mention, you can do a subject access request to the Home Office. If you don't have access to your previous immigration history, you can just request to the Home Office through subject access request and get the full immigration history from the Home Office. So that might also help. It takes sometime 20 to 40 days to get the full record. There is no fees as of now by the Home Office. If you type in Google subject access request to UKVI, you will find the relevant link to do it yourself. So that's number 1, not disclosing previous immigration history or not disclosing material fact. What do I mean by material fact? That's very interesting. So I was doing a consultation a week back. Their client, they pay me like £300 plus VAT and up to an hour for consultation. And this is quite interesting. So He has his own children studying in a private school, independent school in UK on a student visa, younger children, like about 13 years, 14 years old. And he was applying for his independent visa as a sole representative. Now there was a question, do you have a family member in UK and do they intend to join you? Now for this guy, it was a very interesting scenario where he had a family member, his children, but they were not traveling with him. Because his plan is, if he was to get his sole representative visa, his children would switch in the UK from student visa to sole representative dependent visa. So what you can do about it? It's kind of confusing question. So you can say, yes, I do have a family member, they are my children, they are on a student visa, and they are not joining me right now, but they are already in the UK, and they intend to switch if I was to be granted sole representative visa. Now, the question is probably it doesn't have yes or no. So yes is not right answer, no is not right answer. So you pick one which is closely matched to your situation. So in this case, no, right? So his children were not joining straight away, so you can say no. But in additional information box, you always find an additional information box in the application form, right? So you just submit this information in that additional information box. And if you don't have that, then you just prepare a detailed cover letter explaining your situation. The idea is to come clean. The idea is to provide material information which will be helpful for the current immigration application and will be helpful for any future immigration application by disclosing the material fact. So please do that. Provide that additional information which is kind of ambiguous into an additional information box, or provide that into an additional cover letter. So that is number one reason. Number two reason is failure to submit corroborating evidence or failure to submit a specified evidence. Specified evidence is a very technical term. So specified evidence is, let's say if you are doing spouse visa application and you are submitting a letter from the employer in support of a financial requirement. Now that letter should have a specific detail. For example, name of the employee, whether it's full-time or part-time job, the salary of the employee, date, start date of the job, and all that, right? So there are some specific details that should be there in the letter, and for that reason it becomes a specified evidence. For example, if you are required to submit bank statement, majority of bank statements are required to have a bank name, bank logo, and the account number, right? So at times when you download electronic bank statements, it might not have bank logo, and if it doesn't have that, then it would not meet the specified evidence requirement. So you have to be a little bit careful about specified evidence requirement. So that is specified evidence. Make sure you submit specified evidence as per the immigration rules and regulation. You might find this information in immigration policy guidance, and at times you will find it in immigration rules. Now I agree and admit that immigration rules are very complex to read and interpret. You might want to take, of course, professional guidance or advice from lawyers, or if you can figure it out yourself, bingo, do it. Or probably watching this video you might find the right information. So check in relevant policy guidance, immigration rules, that you are submitting specified evidence. Number two, corroborating evidence. So let's say take an example of a visit visa, which is a very subjective application, not objective application. So in subjective application, if you say, I have a son in UK who is working full-time, earning £50,000 a year salary or £100,000 a year salary, and as a mother who is probably overseas wants to go and meet my son who is working in the UK full-time, doing a very good job. Now, when you submit the application, how would the government or the Home Office know that the claim you are making of your son working in the UK full-time is true or truthful? So I would suggest the piece of evidence I can think of as a lawyer based on my experience, that a birth certificate is a good evidence to put forward, or the full passport copy of the son is a good idea to put. So probably at times in some of the passport will carry the name of the parents, so it might be there. If it's not there, we need, of course, to provide corroborating evidence to support this relationship of mother and son, and of course birth certificate of son would be helpful, which will of course contain the name of his or her mother, When you say the son is working full-time earning XYZ salary, maybe 50,000, 100,000 salary, if you don't provide any evidence, how would they know it's truthful? So I would suggest just provide 3 months worth pay slips of son to corroborate with the claim that he's earning handsome salary. Probably his bank statement of last 3 to 6 months. A letter from his employer about his employment, right? So these are the corroborating evidence I can think of. If you see, the way I'm thinking is more logical. There is no specific way of doing it, right? There is no subjective, it is objective. So in this objective way of preparation, you can submit corroborating evidence you can think is corroborating. So this is the second reason of refusal, of not submitting specified evidence or corroborating evidence. Now, third reason is very actually silly. I'm sorry to say that, but it's silly and I have seen it happening. So I was doing a consultation for a Jordanian client. He is my existing client. We advised him for a few complex applications. And we managed to get his children to the UK as under sole responsibility. It was a very complex case. Now that's done and dusted. But when he was doing his application for his wife, he thought it is straightforward. So he became independent leave to remain, a settled person from his tier 2, but his wife was on a tier 2 dependent visa, now with skilled worker visa. So she was on a tier 2 dependent visa. Now he was preparing and submitting his wife settlement application. He finished 5 years, he got his settlement, but his wife did not finish 5 years. So what he did, he tried to submit application form to extend his wife's visa. Now when he was selecting the application, he selected the application called dependent of a settled person, and no, actually he selected a settlement application for his wife, right? And that was actually wrong. His wife did not qualify for settlement. His wife actually do qualify for an extension of a settled person. So actually he selected wrong application form. Now Home Office is nice in a way where they came back and they ask a query and probably ask for the further information, say, Mr. So and so, what do you mean by that? Can you provide this document? Or you selected incorrect form, can you submit the right application? So he came to me for a consultation. I provided him a solution with how he can change and vary the application, so at least he doesn't lose the money he has spent on his application, which is almost like £3,000. 2,300 precisely. So I gave him an idea how to vary that application, change the course of application to at least save the money he spent on his wife's visa application, and selected incorrect form. So it was kind of a stressful situation for him, but at last we found a solution. So remember, the third reason of refusal is selecting incorrect application form. Nowadays most of the application forms for the UK visas are online. So when you select the option, please do select the right option. Now, fourth reason of refusal is not disclosing previous criminal conviction or not good character details, right? What is criminal conviction? So at times even a police caution is bad enough not to get ILR for 2 years. If you have a police caution, you won't be able to do ILR application for at least 2 years. It's called non-custodial sentence. So having given police caution can cause not getting ILR or even a potential refusal for ILR. So you can imagine it's so strict. If you have a fixed penalty, right, that's not a police caution. So let's say if you get parking ticket, that's not a police, it's not a criminal conviction. But let's say if you get a ticket from the police and if you had to go to a court to pay the fine, that might be that might become a criminal conviction. So you see, there is a subtle difference between getting a fixed penalty and getting a penalty for the same offense. Let's say you were driving without insurance, you were driving without driving license, or you probably break the limit of speed, and either you get a fixed penalty or you will be invited at the magistrate court and get a fine from the court. So same offense, but if you get fined from the court, then it becomes criminal offense where you cannot get your ILR for 2 years. So this is a difference about criminal conviction. Now, if you understood that, it's a little bit complex, but what you must not do is not disclose. What it means? You always disclose. When they ask question, do you have any criminal conviction? If you are in doubt, just mention it. Trust me. So if you are in doubt and if you mention, and if it doesn't apply to your case, it will not harm the outcome of your case. People have different thinking. Say, I don't think so it is applicable for me, why should I mention? Think other way around. If you are in doubt, do mention in your application form. There is no harm in providing information more than needed in terms of good character requirement or criminal conviction requirement. There is no harm, or you cannot cause harm by providing more information. You cannot cause harm, trust me. So if it's not applicable for you, Home Office will just disregard that information. But if it's applicable for you, and if you do not disclose, you will get deception charge. That's, as I said earlier, it's very serious, right? Deception is a very serious allegation and it's very difficult to come out of it. So please, mention if any criminal conviction. If you are in doubt, seek professional advice. But you ought to you ought to submit a precise detail about your criminal conviction if there was to be any. Now, the last not the least, number 5, right? This is the last reason. Number 5 reason is following advice of a friend with a similar case or similar circumstances, or reading a lot of forum, right? So there are a lot of forums online these days, and thousands of people, they put comments, advice, which is of course not regulated. And if you follow that, I can see 2 outcomes. Number 1 is you get stress, very, very stressed, right? Because you are reading 1,000 opinions from 1,000 people and you're not sure if it's right or wrong. And you pick up a lot of negative feedback or negative view about when you try and connect with your situation, and you get stressed and you get overwhelmed with so much information. And at times, if you react on it or you follow that, you might even get into trouble because it's not regulated advice. And one more thing, it might look like a similar case to you, but actually it might be different. So that's not a right strategy, I would say, because it might look a similar situation to you, but it might not be identical or exact situation as you think it is for you. So following the friend's advice, which you might think is connected, but it might not be identical, right? So that's not a good idea. Reading a lot of forums are good to share information, but at times it also harm you in terms of bringing stress, having an incorrect opinion, which you perceive yourself. It's just a possibility. I'm not saying something is right, something is wrong, but would I do it? If I was you, my response is no, I won't do it. So yeah, following that forums and friends' advice, I don't think so. It's a great idea, and I have seen people getting refusal and putting themselves in a situation which probably not reversible. So all the very best. These are the 5 reasons I have shared based on my 10+ years experience. I hope it helps. Thank you so much. If you like this video, just press the like button. If you might have follow-up question, or probably you want me to pick up some topic to do another video, then put your comments in the section below, and it will help me, it will motivate me to do more for you. So please like, and yeah, subscribe to our channel. It helps us a lot, and then also it gives us more motivation and energy to do more for you. Thank you so much.